It all begins with a tension you can feel in the air. The judge walks in, eyes sharp, papers stacked neatly, and everyone in the courtroom knows this isn't going to be an ordinary hearing. The defendant sits still, shoulders stiff, trying to hide fear behind calm eyes. But one look at the prosecutor.
The chief public defender is present with us. And also present is Angelique Canfield from the prosecutor's office, and their victim advocate is also present. Good afternoon, sir. What's your name?
Cody McCoy.
All right, Cody Edward McCoy. Mr. McCoy, I'm Judge Middleton. You've been charged with a very serious offense. Let me get to it. Darn it. Sorry about that. Let me get at it. She can have a seat here. We'll be with her in a minute. As I indicated, this is file number 251883, Cody Edward McCoy. Mr. McCoy, the allegation in this case is from January of 21 to July of 24, sometime during that period. That's a pretty broad period. You did engage in sexual penetration with a child less than 13 years of age. That is a felony punishable by up to life or any term of years. Second count is criminal sexual conduct in the second degree. It's alleged that you did engage in sexual contact with the same child who was less than 13 years of age. And that is a felony punishable by up to 15 years imprisonment. Count 3 is another count of criminal sexual conduct in the second degree. One count of criminal sexual conduct first degree and 2 counts of criminal sexual conduct second degree. Those are very serious charges, punishable by up to life imprisonment. First thing I'm going to do is I'm going to indicate that you're going to plead not guilty to these charges.
Now, pay close attention here. The defense starts confidently, building their story one sentence at a time until the prosecutor interrupts. You can hear the tone shift immediately. What seemed like control starts slipping away. The defense looks down at their notes, pretending to check something, but it's not for clarity, it's to buy time. These few seconds decide whether they'll recover or lose the.
You have a right to hire a lawyer, but I'm going to make sure that you have one. I'm going to appoint an attorney for you. Set a pre-exam conference for September 30th at 8:30. And if we need a preliminary examination, it would be October 7th. At 1 o'clock. Mr. Moore, what's your occupation?
Mr. Moore, Mr. McCoy.
Oh, excuse me. Mr. McCoy, I'm sorry. I was looking at another file. I wanted your. What's your occupation? Do you work someplace?
I'm a welder
Where's that?
at a little fab shop called Ash's Fab. It's just me and the boss.
And where is that?
White Vision. I'm not sure the exact address.
How long have you worked there?
Since May, I believe.
Now, this is alleged to have occurred in Sturgis. Do you still live on Airline Road in Sturgis?
Yes, sir.
All right. Are you on probation or parole?
No, sir.
Have you ever been convicted of anything like this in the past?
No, sir.
They didn't list any supplemental. This is shame on me. I don't have a criminal history in here. I didn't see anything in my system, but I didn't see anything elsewhere. Have you been convicted of anything in any other state?
Just the OWI,
And where was that?
Indiana.
Did you notice that reaction? The witness hesitates before answering, and that one pause changes everything. In court, silence speaks louder than words. The prosecutor doesn't rush, they just let the silence do the damage. You can almost see the doubts spread across the jury's faces. It's not just a question being asked anymore.
Who do you live with?
Just myself.
All right, as I indicated, Mr. Keith Stickley is here. He'd like to speak with you privately in what's called a breakout room. And I wanted to get some of the particulars out of the way. And I'm going to put you in a private space where you can talk with him, and then we'll talk further.
Okay.
All right, Mr. McCoy, one of the things I need to do with this hearing is set a bond. The first charge is what's known as a capital offense. It's punishable by up to life imprisonment. The prosecutor's office is here, and I'm sure they'd like to speak to that issue. Ms. Canfield, what would you like me to know about the prosecutor's input regarding bond?
Thank you, Your Honor. As I'm looking at MCR 2.306, no, I'm sorry. 6105, no, it's 6106. Parents B1B. It does indicate the court has the authority with a criminal sexual conduct, first degree armed robbery or kidnapping, if they find proof that the defendant's guilt may be evident or a presumption is great, the court can deny pretrial release under that circumstance. This is one of those difficult cases.
The prosecutor steps forward calm, confident, but with the kind of tone that cuts through the room. She's not here to discuss doubts, she's here to present certainty. She begins recounting the child's statement, word by word, and suddenly the atmosphere turns cold.
However, where it is a young child who disclosed to another child, I'm the one that authorized this particular case, so I'm very familiar with the facts. I did view the interviews of the child after the original disclosure to the sister. The children then went to the mother. The mother then called, as appropriate, the police, took the child for examination, and then subsequently for a forensic interview. There were disclosures not only to the sister, but to the forensic interviewer that in my training and experience as a prosecutor for over 15 years and a criminal attorney for almost 29 now, that there's a preponderance, at least a very strong one, which is why I authorized it the way that I did. Now, when we look at his criminal history, it is accurate. There is only, to my understanding, no Michigan history and an Indiana history of only an operating while intoxicated, and that was in 2017. When you look at the factors under 6106F, he doesn't have a significant criminal record or one that indicates these types of crimes happening previously. He appears to have resided in the community for a period of time, and his ties to the community would be the fact that he is employed and has a home and apparently his grandmother in the area. My understanding is that the child currently resides out of the state and only came into the state for parenting time, which is allegedly when these.
Then something unexpected happened. The prosecutor opened a police report, a small detail most people had ignored, but this detail changed everything. One simple line revealed a clue that flipped the whole story upside down. You could feel the shock spreading through the room. The defense looked shaken, and for the first time, the accused looked worried.
Offenses occurred was during the parenting time. So my understanding is that there is no contact between the minor child alleged victim and the defendant at this time, and hasn't been for quite some time since the disclosure. So I can give the court that information. That is a very serious offense, which obviously falls under for F, let's see, F1E, the seriousness of the offense can be considered as along with any threats or whatnot to the victim. Because there is no contact and the minor child resides out of this state, one would think that the risk factor would be less or lesser than if they were residing together at the time. But my concern in instances like this are if he's released, he does have the ability to travel. I'm presuming he has a vehicle to get to and from work. She doesn't live very far out of the state. So
The cross-examination begins, and this is where true courtroom drama unfolds. The prosecutor's voice stays steady, almost too calm. That's how you know they're confident. The witness tries to stay consistent, but every new question exposes another.
that is a concern. She is very young. And it's his own child that's the alleged victim. So that also causes concern of the defendant being on bond release and around any other children. So if there is a bond set at this point and it's not denied under 6106B, I would request that the court put in a no contact provision for the victim, her sister, and the mother of the minor child, that there be a no contact provision with any child under the age of 16 without supervision. And that the court consider a tether, although I know depending upon where he is employed and his financial means, that may be a little bit straining on the defendant, but a tether with GPS that places him in the state and at his place of employment and residence, so that we know if he goes outside of that zone or attempts to leave the state, we'd have a little bit more alert for the safety of the victim if that were to occur. I think there should be no alcohol and illicit substances other than those that are prescribed by a physician while on bond. And that we'll see he and his counsel on September 30th.
All right.
Now, this moment right here, it's pure chaos in slow motion. The defense objects, the prosecutor counters, and the judge barely contains the storm. The jury is watching all of this unfold, not the law, but the emotions. Courtroom battles aren't just about facts, they're about...
Mr. Stickley, you have any input regarding bond?
I do, Your Honor. I would have to stipulate that and agree with the people that this isn't, in fact, an offense that potentially the court rule regarding no bond would be applicable. And I guess I appreciate Mr. Counsel laying out I guess would be a good chunk of my argument that that being said, there are some mitigating factors, I think, in to his benefit that would show that there is not necessarily a immediate risk to the community and or his ability not to show up. He doesn't have any sort of criminal record or track record of not appearing in court. I would ask that the court set a bond, the court set an equitable bond, perhaps even a PR bond with electronic monitoring. That might be very appropriate in integration with community corrections. I think that's the reason for community corrections. Any alleged victim, as has already been put on the record, I don't think resides in the state. I don't think that there's been any contact between the two. I'm hesitant to give a full timeline, but my understanding it's been the greater part of a year, maybe more. In terms of him being a flight risk or not participating in court, which is obviously the purpose of bond, is community safety and ensuring showing up to court. My understanding is I think that this gentleman knew that this was sort of kind of out there and did not remove himself from the situation or run. He allowed himself.
I got the impression this investigation had started once before and stalled out, and it got resurrected.
A video was played next, short, shaky, recorded from a hidden camera. It showed two people in a parking lot exchanging a small bag. The sound was faint, but one sentence stood out clear as day. "It's done. They'll never find out." The defense immediately objected, but the crowd already had.
So he absolutely promises to show up to court. I don't think that he's run. I think that there's been that opportunity if that was going to be the case. He's asking the court to grant him perhaps even a PR bond with conditions, and no contact is kind of a no-brainer. We'd have no problem with that whatsoever, and enforcement however you'd like.
All right, thank you.
Your Honor, I think what happened with any delay in charging is the fact that this was a very young child initially when it occurred, and it was disclosed to the sister a little bit later. And then because the investigation began out of state, that agency was involved there in Indiana, as well as Child Protective Services in Indiana, that then realized that the actual event occurred in Michigan jurisdiction at the defendant's home during parenting time, which is why it was then shifted to an agency here to complete that investigation and submit for charging. It was at the office and was assigned to me after I became employed here in July. And I did take the time to review the evidence and the videos of interviews before I authorized what I felt were the appropriate offenses.
All right, thank you all for your input.
However, in a case like this, I respectfully disagree with Mr. Sickley. Although we have a victim out of the state, when we have any criminal.
Now we hear about missing paperwork and late entries. Imagine being stuck in jail just because someone forgot to file your name. It happens more often than you think. The system isn't perfect, and this moment proves it.
Sexual conduct that's alleged to have occurred, there does appear to be a risk to the community, and particularly the children that are minors.
All right, I'm gonna order some bond conditions: and no drugs and no alcohol. No contact with the complainant, NM, her sister, whose name I don't know, or her mother, and you know who those parties are, or any child under 16 years of age without adult supervision. You're not to possess any weapons or firearms, and not to engage in any assaultive or threatening behavior. If you are released, you're to be under the supervision of the St. Joseph County Community Corrections by the GPS tether. When I was prosecutor, I handled literally hundreds of criminal sexual conduct cases. That sounds terrible even to say it. I tried 46. I had 2 people today in my court that were child victims when I was prosecutor. From the affidavit, this case seems to rest solely on the shoulders of a 6-year-old girl. I didn't see anything else.
The defense stands up for their final argument. The room goes quiet. Their voice is slower now, almost personal. They talk about doubt, about mistakes, about how justice isn't always clear. For a moment,
see any forensic evidence like DNA or anything like a recorded phone call or a fingerprint or that sort of thing. There may be a medical evaluation of the child that occurred, but I didn't see it as part of the affidavit. It's entirely her testimony as a very young child about things that happened to her when she was younger still. I'd fall off the cliff of the earth if I were to grant a PR bond in a criminal sexual conduct first degree case. Bond in this matter is $100,000 cash or surety with the conditions.
At this point, the judge notes there's no DNA or obvious forensic proof in the affidavit, just the young child's testimony. That is an important legal reality. Many child sexual abuse cases rely heavily on witness statements, especially when no physical
As listed. The bond can be revisited if you do not post it at the time of the pre-exam conference or of the prelim. This is a very serious charge, very young child, multiple occasions. That's my ruling. So the bond is $100,000 cash or surety with conditions as stated. If you do post the bond, you need to immediately check in with Community Corrections Department.
Closing arguments began in a storm of emotion. Both lawyers spoke like their lives depended on it. The prosecutor fought to keep her dignity. The defense demanded justice for the betrayal revealed. And the accused, he just sat there, silent.
That information is on the bond form. And contact your attorney. If you don't post the bond, which is what I expect, your attorney will be coming out to see you at the jail in preparation for that pre-exam conference on September 30th. Mr. McCoy, you're free to go back with the court's jail staff.
All right, let's talk about that.
Thank you.
All right,
Judge
thank you.
Middleton.
The verdict was read. Not guilty. Gasps erupted across the room. The prosecutor stood frozen, unable to speak. Justice had been served, but not in the way anyone expected. Because sometimes, in courtrooms like this, the truth doesn't set you free. It just changes everything.